Hello friends, in the series on the income tax cases, today we will discuss the case of Sanjay Gandhi Memorial Trust versus Commissioner of Income Tax Exemptions and others. This case has been reported in 455 ITR at page number 164 and the matter has been decided by Delhi High Court and the date of the judgment is 26th May 2023. Friends, this case is very important for the understanding of jurisdiction of the assessing officers. There is section 127 which talks about the transfer of cases. Generally, it is understood that the transfer of case of the assessee is done only in the cases of search or where even if there is no search on the assessee and if the material related to the assessee is found at the place where the search is made, then the transfer under section 127 can only be done. This is the generally misconception. In this case, the case of the assessee was transferred from one city to the another city under section 127 and there was no incriminating material or the seized material against the assessee with the department. The assessee filed the writ petition against the transfer under section 127 by saying that since I am not a party which is covered under search, no incriminating material has been found related to me in the search, so my case should not have been transferred under section 127. The assessee pleaded on the basis of the clause 2 of the notification dated 13th August 2020, which talks about that if during the assessment proceedings, the principal commissioner of National Faceless Assessment Center feels that the case of the assessee should be transferred from the National Faceless Assessment Center to the jurisdictional assessing officer, then he can do so by taking the permission of the Central Board of Direct Taxes. In this, there are two important things. That first of all, the assessment of the assessee should be going on, and second, the permission of the Central Board of Direct Taxes should be taken. But this is applicable only when the assessment is going on. In this case, the assessment of the assessee was not going on and the case has not been transferred from the National Faceless Assessment Center to the jurisdictional assessing officer. So the court said that this clause is not applicable to you in the present case. The case of the assessee was transferred from one assessing officer under one principal commissioner to the assessing officer of other principal commissioner by the principal chief commissioner. In this regard, the court said that the National Faceless Assessment Center scheme under which the assessment is being done holds the concurrent jurisdiction with the jurisdictional assessing officer, meaning thereby that when the case is picked for the scrutiny, at that time the case of the assessee is with the jurisdictional assessing officer. But for the purpose of the assessment, the matter is transferred to the National Faceless Assessment Center, and when the assessment is completed, again the records are transferred to the jurisdictional assessing officer. It means that the National Faceless Assessment Center and the jurisdictional assessing officer holds the jurisdiction on the assessee at the same time. But section 127, if the case of the assessee is transferred from one city to the another city, then according to the court, there is no prejudice to the assessee because now when the case is transferred to the central circle, even in that case, the assessee can submit all its documents through the e-proceedings portal. The Delhi High Court said that even if no incriminating material is found related to the assessee, and even if the assessee is not a searched party or is not related to the search in any way, in that case also the transfer can be done, because the transfer is an administrative act and generally the courts refrain from themselves from interfering in these matters. The court said that when the case is transferred to the central circle, in that case the assessee has to submit all its documents through the e-proceeding portal. So the assessee nor the professional of the assessee has to visit that officer very frequently for submitting its papers. So there is no prejudice to the assessee at that time. Further, the court said that under section 127, the principal chief commissioner can transfer the case at any stage, meaning thereby that even before the assessment or during the assessment, from one assessing officer which is under one commissioner to another assessing officer which is under another commissioner. And the assessee do not have any right to be assessed by the faceless assessment officer. It is not the right of the assessee, because in this case the assessee was saying that there was no need to transfer my case because there is the faceless proceedings, and there now the case of the assessee should be completed in the faceless regime. So if the department feels that the case of the assessee is to be done not by the faceless scheme, then whether it is a search case or not, the department can choose in this way that the department can transfer the case under section 127 for the purpose of better administration, for the purpose of coordinated investigation, and the assessee do not have much say in that. Although there is a provision in section 127 which says that an opportunity of being heard should be given to the assessee, but there is no prejudice to the assessee if the case is transferred under section 127 from one assessing officer under one commissioner to another assessing officer which is under another commissioner. The court also said that section 143 subsection which was brought in 2019, which is related to the e-proceeding and which is governed by notification dated 12th September 2019, and there is section 143 subsection 3b which talks about faceless proceedings 2020 and which is governed by the notification dated 13th August 2020. They do not say that the assessee has a vested right to be assessed by the faceless assessing officer. If the notification says that if the commissioner of the National Faceless Assessment Center feels that the case of the assessee is to be transferred to the jurisdictional assessing officer, then he can do so, because the jurisdictional assessing officer and the National Faceless Assessment Center in which the faceless assessing officer makes the assessment, both do have the concurrent jurisdiction over the assessee. So in this case, the court declined to interfere in the matter by saying that the plea of the assessee that there was no incriminating material, there was no seized material, and my case should not be transferred on this basis, this is not correct, and declined to entertain the writ petition of the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is SANJAY GANDHI Memorial Trust versus Commissioner of Income Tax Exemptions and others. And this case has been reported in 455 ITR at page number 164. The matter has been decided by Delhi High Court and the date of the judgment is 26th May 2023. Thank you, friends.